Hello friends, in the series on the income tax cases, today we will discuss a case which is based on the addition under section 153C read with section 69C on the basis of a satisfaction note which does not reflect any information which has a bearing on the escapement of income of the assessee, and that without relating information with the seized material which has been found in the premises of the assessee who has been searched. The issue before the Cochin Tribunal in the present case was that whether these type of additions based on a satisfaction note which has been prepared without application of mind and without having any information which is related to the escapement of income of the assessee is valid or not. This issue has been taken up by the tribunal in the case of Leissure Tourism International Private Limited versus Deputy Commissioner of Income Tax. This case is reported in 131 I.T.A, Tribunal page number 226, and the date of the judgment is 13th February 2024. The present case relates to the assessment year 2008-9 to 2010-11. In the present case, there was a search in the K group. The assessee was related to that K group, and when the search was made on K group, there was some loose papers found on which there was reference of two buildings which have been constructed by K on behalf of the assessee. On the basis of that loose paper, the satisfaction note was recorded, and in that satisfaction note there was no information which has bearing on the assessee's escapement of income, and that too without any reference to the seized material. There was no signature on that loose paper of the assessee, and there was no reference of any turnover, much less suppressed, of the assessee in that loose paper. But the assessing officer, on the basis of that satisfaction note and that loose paper, made the addition under section 69C of the assessee, and the assessee challenged that addition under section 69C in the tribunal on the basis of satisfaction note which had been prepared without application of mind and on the basis of mechanical approval under section 153D. When the tribunal heard the matter, the tribunal was of the very considered view that the satisfaction note must reflect information which has a bearing on the total income of the assessee with reference to the seized material. The tribunal said that exhibiting the nature of the document for assuming the valid jurisdiction is very necessary, and the tribunal was also of the view that the appellate court can not read a document establishing the jurisdiction other than what is mentioned in that document. The tribunal said that in the present case, the satisfaction note does not contain any information which has a bearing on the income of the assessee, and there is no reference to any seized material other than that loose paper. So friends, this case becomes very important because it has been seen that whenever the proceedings under section 153C are being opened, they are just being opened on the basis of a satisfaction note prepared by the assessing officer, whether it is the assessing officer of the searched assessee, whether it is the assessing officer of the other assessee, or in case when the assessing officer of both the assessees are same, even then this satisfaction note is prepared only for the namesake. There is no reference of the seized material. Even in some satisfaction note, there is no reference of the amount involved, and the satisfaction notes are also prepared in a consolidated manner. So there are a number of the cases of the tribunals in which the tribunals have held that until and unless the satisfaction note is year-wise, the omnibus satisfaction note is not valid in the eyes of the law. So in that series, this judgment is also valid, because in the present case, the revenue was not able to convince the tribunal that the satisfaction note has any information which has bearing on the income of the assessee. So for the satisfaction note prepared without application of mind and for the approval given without application of mind, the additions were quashed by the tribunal. At the end of this video, once again I am repeating the name of the case. The name of the case is Leissure Tourism International Private Limited versus Deputy Commissioner of Income Tax, and this case is reported in 131 I.T.A. Tribunal at page number 226, and the date of the judgment is 13th Feb 2024. Thank you, friends.